we're going to do, we'd like to do the expert CLE first, and then Mike's going to do the class action CLE, and then we're going to do then I'm going to do something on liens. And we have a lot of material there, and so we'll just kind of jump into the CLE. So this is Mike Flannery. So Mike and I've known Mike for a while. Mike is a really accomplished lawyer. He practiced in a couple different firms. He's now with the Cuneo, Gilbert, and LaDuca out of Washington, D.C., but he practices all in St. Louis. He's been with some St. Louis firms. He's focused on really complex class action work, so I brought him in and asked him to help and talk about class actions. He's also done a lot of expert stuff and a lot of Daubert stuff, which dovetails well. So thanks for doing it.
You're welcome. And I can just
Just and he's an amazing lawyer. We're working on a class action together right now. I've enjoyed working with him.
Well, and I know that you all know Gary way better than you know me. So just a little bit more about who I am. So you say, where's this guy from? So I came to St. Louis in August of 2000, and that was after working in D.C. as a defense guy for a little while. And then 3 years at a plaintiff's firm in D.C. that did predominantly class actions. I did securities, antitrust, and a whole slew of other kinds of cases. Then I was in San Diego for 3 years at a firm that was then known as Milberg Weiss, Burchett, Hines, and Larax. Some of you may know that firm. It's now known as Robbins Geller. And then in 2000, I moved here, and I was working at a firm in Clayton, now known as Carey Downey Lowe, up until 2012. And then I joined this firm that I'm at now, Cuneo, Gilbert, and LaDuca. They're based in D.C., as Gary said, and I'm their St. Louis outpost. So my background is predominant in class actions. Who in here has done a class action? That was one of my first. I'll say so. Three folks. And what kinds of class action cases did you work on?
Antitrust.
It was antitrust. What was yours?
Wage violations.
Wage and hour.
Franchise case. Franchise cases.
Okay.
Some of the hernia mesh cases.
Hernia mesh cases. Okay. All right. So since my practice has been since the mid '90s, although I've done a lot of mass tort type cases, predominantly my cases have been class actions. If I'm talking over you and I'm saying something that you're like, I have no idea what that guy just said, just please raise your hand or ask a question. It's fine. Although we are going to be talking about experts, and of course that has its own application across cases. But when I get to the class stuff, feel free. Again, if you haven't had experience with it and what I've said sounds like Greek to you, just raise your hand and ask a question.
Thank you. So Missouri's expert rule is radically changing. We had the Frye standard. We're going to the Daubert standard. If you have the materials, when you get to the materials, I set out in exactly what the old law was, exactly what the new bill is, House Bill 153, and Rule 702. So what's happening is 490.065 is completely thrown out and is completely replaced, and it tracks 702, Federal Rule 702, but it has more additional provisions. So it still contains some of the protection. So you can still have an expert if their opinion embraces the ultimate issue at issue in the case. They can talk about liability or the defendant breached the standard of care. They can talk about causation and experts. But it does have this, has to be information reasonably relied on by experts in the field and has to be peer reviewed and has to go through that gatekeeping aspect. So there's a lot people don't know. People are afraid of it. I don't think it's going to be as bad as we think personally. But there's some interesting statistics. When Daubert came out, The amount of summary judgments greatly increased. The amount of striking of experts and dismissing cases greatly increased. 92%, we have in the materials, of the rulings and Daubert motions are against plaintiffs and pro-defendant. And I've been on both sides of those rulings. But basically, and this is effective August 28th. This is effective for trials effective August 28th. So I don't think that the timing of filing of your case is going to materially matter. So any cases that are going to be tried before, great, get them tried. But if that ain't going to happen, you're going to be prepared to deal with that. And we're going to talk about some more specifics. Now, Federal Rule of Evidence has basically 702 has basically 4 points that we talk about on the top of page 4. But if you have the materials on I have a presentation on experts. Mike did one too, so we have 2 things. We also have a bunch of addendums. We have a bunch of samples. I have an example of we tried a case last year about this time last year. We had a voluminous Daubert motions on both sides. I've included a 30-page opinion by Judge Shaw, which struck some statistical evidence on the part of the defendant, General Motors, which enabled our accident reconstruction and our product liability folks to do it. But it's the way these interplay and these rules interplay are very interesting. So the new expert rule, and I'll turn to you in a minute, Michael, is it doesn't prevent a corporation or person from testifying to the reasonable market value of the owner's land. That's interesting. You know, we have our rural legislators need to have their farming stuff protected. You don't have to talk about the facts or data before you give the opinion, but the rest of the typical requirements are the same. And we think that trial judges are going to have Daubert hearings, whether or not they have a formal hearing or whether it's just on the paper depends on the judge. I think our pre-hearings are going to be more important, and they're going to act as more of a gatekeeper. When Daubert was remanded back to the Ninth Circuit, and there was this Judge Kaczynski who wrote a great dissent that I've included in the materials with a lot of cites about the gatekeeping nature and what judges are going to be forced to do under Daubert. So that's just a little bit introductory to orient us as to what's changing and to where it's going to be. And I don't think it matters when your case is filed, as I said. And then I want to talk about treaters, talk about other experts, because that's where kind of the rubber hits the road a little bit. But I thought I'd turn to Mike and let him share his thoughts as well.
Yeah, so I come at this basically having just done a Daubert hearing in the Northern District of Illinois on April 17th in front of the Honorable Amy J. St. Eve, great judge up there. And I have a product defect case in front of her involving Whirlpool ovens, in-wall ovens. And the allegations in the case are that the ovens have a defect, and that is that when you run the self-clean function, the oven shuts down and becomes unusable. Okay, so that was the issue. That's the case. It's a big class. We say that the wall ovens that were built on a particular platform by Whirlpool from 2002 to 2014 all have this defect. So I had an expert witness, and they had an expert witness. Their guy was from an outfit called Exponent in California, who I've used before, so I know how good they are. And I had a guy from Pennsylvania who's from a smaller shop. And both sides put in expert opinions, and the judge only had a Daubert hearing on my guy. So I was a little nervous about that. But I think, so that informs me. I've been, just wrestling with all this case law and what it matters. And I think, Gary's exactly right. You really need to look at the fundamental roots of why did they have this rule? Why did this case come about anyway? And for me, it's really about the courts trying to weed out, or at least it was about the courts trying to weed out junk science. It was the courts trying to make sure that nobody could walk in with somebody with a crazy, bogus theory who had nothing to back it up, who'd done no testing, who walked in and said, "Hi, I'm an expert. I have several degrees, and you should pay attention to me." And so the courts, I think, rightly came up with this well, they came up with this test, whether it was right or wrong. They came up with this test. It was incorporated into Rule 702. And it, as Gary says, a gatekeeper function. And the bottom line is that these two concepts of relevance and reliability, whatever else the judge is doing up there on the stand thinking about your witness, you need to be playing to relevance and reliability. That's, at least I felt like I had to be getting my witness in the testimony I was eliciting on direct to be able to say to the judge, because you're not talking to the jury at this point, you're just talking to the judge. By the way, in that moment, the rules of evidence don't apply. It's an odd concept, but you walk into that hearing and the judge is not bound by the rules of evidence except as to privilege. So pretty much anything can come in. And you need to be, and as I said to my witness in prep, and I'll talk about all that prep, and honestly going back to actually writing the report, that's what you need to be thinking about. I said to him, and this is a basic trial concept, you need to be talking to the judge. You need to be, you need to be convincing her that you are competent, that you reviewed enough information, that your theory's not cockamamie, that you base this on engineering concepts. So again, Daubert it's the gatekeeping function, and there's a lot of cases. I put in my materials a case called Fluid Master. This is not the Westlaw version, but it's a thick case. And Fluid Master is by Judge St. Eve's colleague, Judge Dow. And Judge Dow goes through like 15 experts. And what you find as you read through it is that the judges are, they'll slice and dice. If your expert has 5 opinions and 4 of them are well supported and one of them's cockamamie, you're probably going to lose the cockamamie theory. That isn't well supported. So again, this is, as this comes in, I think, I don't know, I guess
it dovetails with, sorry, go ahead.
Yeah, I think there was I feel like there's in the Missouri State context, there's this overarching maybe thought that if we bring this in, we are definitely going to flush a lot of, bogus cases. I don't think that's necessarily true. No. I think that the standard is one that can be met pretty readily.
If you're going to bring a lot of bogus cases, you won't be in this business for long because the juries will figure that out. We know Jim Onder had a bunch of these verdicts in the city with this talc powder case, but those cases were thrown out because of this junk science issue in New York, and that was bad. That was particularly motivating for the legislature to enact this statute. And it really dovetails with a motion in limine. In the case that I referenced before, the judge will go through and figure out what opinions they're going to permit and what not permit. So it can be don't think it can be a Pyrrhic victory if you go in and your expert. And the judge says, yeah, your expert can testify, but they're not going to be able to say X, Y, and Z. You really got to look at that and be careful about, are you going to get causation in? Are you going to be able to do this? We had a case against General Motors, and it was a product liability case and a rollover case, and the judge excluded the defendant's statistical evidence. The defendant sought to bring in a statistician who came in and said, because the incidence of injuries from rollovers isn't high enough, it means it can't be a product defect. We quoted some of those great Mark Twain quotes about statistics, and we were able to keep that witness out. However, the judge did go in and the other thing is it's kept in this is the extent to which experts can rely on hearsay and whether that can be admissible. And the new provision talks about specifically about if the expert's going to rely on evidence that would not other be admissible, they can, but they're going to do a test whether the probative value outweighs the prejudice, which is what judges many times weigh in other issues. So it really does dovetail with motions in limine. So if there's an issue that the judge is going to keep out, in that case, we had incidents of, whenever you do a product liability case, you have OSIs, other similar incidents, whether you get them in and how probative they are. And a lot of times it is a way to, if you're in a strict products liability, it is a way to bring those in. But our judge specifically kept out opinions where our experts were talking about other seatbelt designs, other types of designs, and the judge drew a line. He was very fair. I thought he did it, but he did ride the line, and so he's gonna ride that line throughout. And just like a motion in limine, just because you win the battle in the first place doesn't mean that doesn't change down the road, because an expert's opinion that is initially kept out because of a specific reason, not peer-reviewed or science, but because of this probative stuff, the other side can open the door. And they did in that case. And we were actually, they came up in an opening argument. They made a bunch of claims. We got the transcript, and we had a hearing outside the hearing of the judge. And then we were able to bring that stuff in. So as anybody who's tried a bunch of cases know, a motion in limine, it's great when you get it, but you need to be vigilant about those issues throughout. And so if you need to watch what the defendant does throughout a trial to see if later those opinions will come in.
Question.
Just a quick question. I've gone through Daubert stuff before, but never really had to have a hearing. We usually worked it out. And the first thing is, with the reliability of what they're saying or what their testing is, did you guys ever feel necessary to bring an outside expert to come in and say, this expert's doing what we all do? In other words, have additional expert testimony. And then what is the timing of doing the Daubert? I mean, if like you were saying, Gary, you don't think it applies. When I get these lawyers entered in my cases, I'm going to say, if you're intending on relying on this law that comes into effect in August, I want to know that. And I want to have the hearing sooner than later. I don't want to pay. You know what I'm saying?
Sure.
More cost thing.
Two things. One of the things I did, and again, I know the materials and Mike and I actually talked before his Daubert hearing. I have a practical expert tips, and I have how to present the testimony at trial. That's point 8 in my presentation. How to do it. It's really a roadmap of how to direct exam these guys. So to answer your first question on reliability, I would not bring in another expert to comment on my expert. But what you want to do is you want your expert to have in his pocket, i.e. able to cite immediately, I like to say, textbooks from 20 years ago saying the same stuff he's saying today. And so you want you want your expert to be able to say things like, yeah, I learned in graduate school 30 years ago such and such and so, and I'm taking this well-established, long-standing rule in science that's actually a safety rule. And why do we have these rules? So when you present these issues, you put the expert on the stand and say, well, I learned that this particular safety rule, you can't have pinch points. You can't cut where you can't see for a doctor. You have to have a slip, trip, and fall prevention program for a premises liability case. In a truck case, you have to inspect your vehicle. You abide by the motor vehicle safety regulations. So whatever that specific thing is, you establish that it's a long-standing principle, that it is well peer-reviewed and accepted, and you're taking that old rule and you're applying it in this case. And any good expert will say, yeah, I remember the Smith article from 1982 in JAMA or the blah blah blah, and then they'll know that. So that's how you address that. Regarding the hearing, I think it's going to be. I think most trial judges, even though they're going to have Daubert standards, are probably in their brain going to apply Frye for a while. Yeah. But at some point, they're going to be more, and it depends on the judge, right? And I think it depends on this fundamental fairness idea in their gut. Is this junk science, or is this really the same stuff that I've been letting in for 20 years? But eventually, it's going to maybe move closer to the federal standard. And I think that's what you ask when you go into that case management conference, or you schedule that pre-trial, or et cetera, judge, when are we joining this battle? Now, the way it typically comes in procedurally, it comes in a motion in limine to exclude the testimony of blah, 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 or to exclude the opinions of such and so, or we're gonna be able to I understand they're going to present that doctor, but when he starts talking about when Berger gave him a bunch of other medical and from other treaters and wanted to have him talk about causation, or there's no degenerative condition, or et cetera, that he's now an expert. So now he needs to do a report. Now he needs to do this, and this. So we're going to exclude that. And then you're going to set your pretrial. So I think it's going to change the nature of the pretrials, where it's just kind of, hey, yes, Steve.
When is an independent report required? Let's say you make a list of opinions they're going to provide. When is an independent report actually required?
So I'm going to answer like all three of those. I come at this from the class perspective, and in this case that I just did, Gary's exactly right. I mean, in that case, in prep and in the testimony, I wanted my expert to say I based my opinion on the scientific method and concepts of fluid mechanics and solid mechanics and physics. And so would I bring in another expert to opine on my guy? No, I wouldn't. And when it usually comes in, and whether there's a report, sort of that last question, in the class context, it's almost always in the context of class certification. So the judge sets up a schedule that says, plaintiffs have to file their motion for class cert by X. Typically in an antitrust case or product defect case like I was doing, you are coming in on your class motion with an expert report. And expert discovery usually has taken place before you ever get there. Okay, so yeah, in the big cases, in the commercial cases, antitrust, product defect I'm working on, yes, there's a report. Yes, it comes in alongside and at the time of class cert. And again, what you're trying to elicit in those moments is your guy can be relied upon. These are sound scientific, long-standing principles, and and this is the important point, he reliably applied those principles in rendering his opinion on this case. It's going to help the jury. Again, you're talking to the judge who's the gatekeeper, and you're in a hearing that isn't an evidentiary hearing, and it's not talking to the jury. But in some sense, you're telling the judge that your person, your expert, will help the jury. So, for example, in my case, I was trying to say, listen, when you look at a wall oven, you don't necessarily see airflow. You don't see heat transfer. You don't see those intuitively. My expert, who the defendants, by the way, one of the first factors is he qualified? And in my case, the defendant stipulated that he was qualified as a mechanical engineer. So, I'm saying to the judge, getting him to testify that he, as a mechanical engineer, can talk about principles of solid and fluid dynamics and physics and heat transfer, which will help the jury understand why this oven is defective.
And then, thanks, Mike. And when each of these cases, you get so into the issues in that case. The good news is there's a wide body of law on Daubert, so you can go. There's a million cases on this in different fact situations, and so that's what it's going to turn on. The issue, my issue that I'm worried about in this is, what do you do with a treating doctor as a plaintiff's lawyer who's going to come in and testify about causation and damages, because they're not a hired expert. But they have expert opinions. And what I typically do in cases is I'll get the treater and I'll go depose them and I'll go give them some other records. I'll give them the ER records and blah, blah, blah. And then I want them to say there's causation and that kind of stuff. So is that an expert? So I was in front of Carol Jackson 2 weeks ago, and I specifically asked her about this, and she said treaters aren't experts, and that's been her deal along. But she's like an old school trial lawyer, and that's how she's kind of, I guess she's run her courtroom. I've also been in some of her colleagues' courts, and I had to get asked for a continuance one time because I was all ready to go, and she said that I needed reports from my treaters because they were going to talk about degeneration, some of the typical issues that we encounter. And I know, Jerry, you and I, in a case I tried with Jerry, what about that physical therapist that I put on? Can a physical therapist come in and give? I tried a case with Jerry, and I put on this physical therapist, and I thought she was great, but I don't know if she'd come under Daubert if she could render some of the opinions she did, because she's a physical therapist. How she's going to talk about causation? I can talk generally. You treat a lot of people like this. Are these symptoms typical of what someone happens? Yeah, and she can talk about that. So it's going to be judge by judge, I think, in some cases. But that's what you want. You want to get out right away in the pretrial, judge what you're going to do, because a lot of treaters, I mean, it's hard enough to get a depo from them, let alone have them do an extra report. Here's some tricks, though. I say their records are their report. There's their report. Here's their records, and then I'll disclose. I'll say, and then the Missouri disclosures aren't really disclosures. You don't say squat. But I have a case right now where I don't even have to do it. But what I had actually, it's a trucking case. There's some fatalities, and I don't have to do a report. But I said, you do a report anyway, because I want to show the other side we know our stuff, we're on board, and this is what they're going to say. And I did it when I didn't have to, because I think that we look better anyway. Treaters aren't going to do a report for you typically, or you can use their records, or sometimes you give them all the old records and you pay them a little bit for their time and say, can you just do a letter that says you looked at all these records and then you think such and such and so and so. That can be done too, but it's hard to do in the $20,000 auto case where you're being offered $5,000, and so I think the defendants are going to be, and those smaller cases, I think that can really hamstring folks. Did you have anything to add on treaters? What's your experience with that, Mike?
No, I think that the concept that I would build into that is, again, I think what Gary's talking about and what translates to me is you've got to do a lot of work up front with your expert. In other words, one of the things I asked Gary to copy, I can hand it out. Everybody can have it. But there's a checklist for things you should be thinking about in your very first meeting with your expert. Because if you're at the Daubert hearing and you're just starting to think about what Daubert means, it's too late. It's too late, right? So, this is the kind of thing that I would say, especially whether it's a treater or in a big commercial case, an antitrust case, product defect, anything like that, you need to be talking to your expert about what that hearing might look like. And so that they're starting to think about, especially if they're writing a report, what to include in that report. Right? I think that as this plays out, and this was true in the case I had, both sides are going to file their Daubert motions. Even if the other side's guy looks like bulletproof, he's from Harvard, he's got 85 degrees, he wrote the book on the thing that you're talking about, you might file a Daubert motion because they filed one against your guy. And you can find some aspect of his report that you think is not quite up to snuff. Oftentimes, the judge will let those two things will just cancel each other out. In my case, it didn't happen that way. And I think that what you have to inculcate this in your expert is you need to be thinking about these. Is it based on sufficient facts? Am I reliably applying these principles? And that ultimately is what the judge is wrestling with. In my hearing, in the moments where that I felt like the judge I got a hint about what the judge was struggling with. She started to question my witness. I knew this would happen. She's a very smart judge, and I prepped my guy. You listen. At some point, she's going to stop me, and she's going to start asking the questions, and that's the moment where you have to shine, right? You can do well with me, but when she asks you the question, you got to be on point. And this is what she got down to the brass tacks. What she was struggling with was, had my guy done enough to figure out what was actually literally underneath the causation of the defect? Had he said enough about how the mechanism of the defect worked? Now, I argued hard and long that wasn't my job. Whirlpool didn't figure that out for 15 years. Why should my guy have to figure it out? But she asked him a lot of questions about that. So that's, I think, I'm on pins and needles a little bit waiting for this to come out. But I think at the end of the day, the first time when you've identifying what witness would be, what expert would be a good witness, and that's an important question. But when you've figured that out and you're sitting down with them, you just start talking about the Daubert principles, the first conversation you have with that expert. So they know what's going to be expected to them if it ever gets to the hearing. It might not, but if it does, they need to know that. Yeah, question.
This might be a dumb question. But
no question is dumb. Go ahead.
So, does the statute say that the Daubert standard is going to be, the federal Daubert standard is going to be adopted? And as well as the case law surrounding the Daubert standard? In other words, on the case law and all these different ancillary issues surrounding it, is that being adopted whole cloth?
Yeah, I haven't read the specific statute word for word, but my sense, John, is the answer's almost certainly yes.
What was the question? Again, I apologize.
Does the statute incorporate the federal jurisprudence as well as the standard?
And no, to the extent it echoes 702, it does, but it's more. Our statute has more than 702. But I think it's gonna. I think cases. If you're trying to put in a mechanical engineer to say there's a product in a stove, an oven, or the rollover defects in a van, if there are other cases on those issues, that's going to be highly, highly probative. Okay. So there you go.
Yeah, persuasive authority.
Dan, did you have a question before we were cruising, or did we address it?
I just want to get your guys' impression. What I've done with these guys, especially in lower value cases, is I'll interview the treater, either go see him or on the phone, and then I'll write him a letter, which essentially is a report, and say, here's what you've told me. And if you disagree with any of this 3-page letter, let me know. And then I go to depose him.
Right.
And I hand him the letter. And then I mark it and then ask him, is that essentially, if you were going to write a report, is that essentially what you'd say? Yes.
I get it. I have an example here. I would be very careful about writing his report for him.
Right.
I had a case I tried, and I have the appendix here. I have my cross of this other doctor where the other side wrote his opinions, and he handed it to him, and I sat and so the lawyer wrote your opinions for you, right? Yeah. And he typed that out, right? And he handed me that right before I asked you what your opinions were, right? I just saw that off camera, right? Da-da-da-da. So I'd be careful. I would never write that report for my expert. I'm very careful. I always want to see it in draft facts to me, not signed, so I can talk to people about it. But I mean, if it's the other thing we did in this case that I tried a year ago is our client was gravely injured and medical from all over the place, but that case was worth it. We hired a doctor to come and look at all the stuff and review it and come in and testify. But in the smaller cases, I would call the doctor. I go meet with doctors. I do the same thing informally. I'd say, doctor, can you dictate a quick letter saying that you reviewed all the medical, you reviewed this, and this. You think it was more likely than not caused by this incident. They're going to need future surgery. Da-da-da-da. Just get them the key points in that, and then you go depose them, and then you go have that Daubert hearing. But I have some things. Anything else on that before? Because I want to talk a little bit more about treaters in that.
Yeah, just one real quick thought. I really think this is going to come into this the prong that says sufficient facts. Did your expert rely on sufficient facts? And in reading the case law and in my closing argument, I was talking to the judge, and what are the cases like where you get struck because you didn't satisfy the Daubert standard? What does that look like? And I read those cases that the defense cited against me, and the general theme there is that the expert did next to nothing. For example, there was a rollover case where the expert's testifying about the seatbelt, and the expert turned in a 1.5-page report, but did not review the testimony of the injured party, the plaintiff, any of the other witnesses. And there was this huge evidence cache that he could have looked at, and he looked at nothing. So I think you really have to think, what did my guy look at? What would inform him? What's relevant in the context of the case? And that can be, like for me, it was deposition transcripts of the primary witnesses of the defendant. Yes, a lot of documents. They gave me thousands of documents, and I gave him a lot. And they'll ask, well, did you select these, or did your lawyer send them? Okay, but if he looked at a lot of material, that's okay. So, I think you're going to get kicked on Daubert when your expert really, really does almost nothing, but renders a really crucial opinion in the case, right? So I think they have to do some like that.
Yeah, and the challenge is going to be so let's say, so you go to your depo, you think you got it you come to this hearing, and then what happens when you're 2 weeks from trial and the judge says you didn't give enough facts in that question, you can't play that depo, or that and with a treater, if you get a persnickety judge, there isn't a lot of, one of the things we talk about is what other body of, is this peer reviewed? What other body of stuff is there? Is there a lot of stuff on whiplash and degeneration? I mean, we all, if you do enough of these depos, there's some, but there ain't a lot. And your doctor is not going to have gone out and looked at this study or this study or this study on whiplash. So one of the things that I am sure Matta will do, or I will do, or these lawyers, we won't share it with some lawyers, but what we'll be doing, I'm sure, is getting a packet of, here's a bunch of articles, send it to the treater, have these in your pocket, so when you sit up, and they all know, I know that whiplash causes these forces on the neck, or I know this, and we've all taken those depos, and some doctors can cite it better than others and stuff, but maybe get a packet of stuff to shoot to the guy so that they have that in their pocket. You're going to have to be, I think we're going to have to be more vigilant about listening in depos to those form objections from the defendant and those other stuff, because I think they're going to be able to then use those later and say, hey, I did that form objection, foundation, he asked the causation opinion. So one of the things we teach and stuff is when the other side makes a form objection, you really need to turn to them and say, what's your form objection? And especially now with Daubert. And then they kind of don't want to say, oh, you were late. Well, no, I need to know a little bit more. What's your form objection? And you need to say, specifically, I'd turn to them and say, because if your form objection is because we haven't adequately established a foundation for this under Daubert or Daubert, if you're on Gravois, I need to know, because I'd say, because look, the new statute's got a lot of prongs. Which prong do you think I'm failing here? Because you can't sandbag me later. Because if you are, I want to ask him now, because I didn't go into detail about the degenerative back condition and whether or not it's the vertebrae squashing that's causing the impingement on the nerve, or whether it's the swelling or the enzymes, or whether it's the facet that's, who knows what you're getting at, but I need to know. Or are you saying that I didn't give the guy enough studies? Or are you saying that he didn't see the ER report? Or are you saying, what are you saying? What's your challenge? Because you can't sandbag me 2 weeks before trial. Because if I'm taking the doctor's video deposition to prepare later, like on my fancy video camera that I have here, my high-end equipment, I want to know, because I'm not going to call that doctor in again. But you see how that's going to really hurt us on these small cases, and I think those are some things you want to do. And on the defense side, meaning from sitting here from the point of view of a plaintiff's lawyer, so on the defense side, I think the defendants have to deal with this too. And there's one of the examples I have in here is a cross I did of someone who never saw my client. And so when you have can you have a defense doctor come in, not see the client, not see the plaintiff, and come in and review the records and give opinions? And is it really a peer-reviewed, objective opinion if all this doctor's done for 30 years is come in and do defense IMEs and come in and say the same thing 30 times? I think you have an argument saying they're not doing that, Judge. What they're doing is they're bought and paid for. I kind of say that anyway to the juries, but that comes into a Daubert standard. Is this really a peer-reviewed, objective, neutral expert? One of the things that I have some practical expert tips and some other things. One of the things that in Daubert, that I like to do in crossing experts, and that I think may assist here is you talk about the scientific method with experts, because everybody has a scientific method. And the scientific method is you start from a position of neutrality and you have a hypothesis. And I learned this from a great book called Exposing Deceptive Defense Practices. If you guys want a resource, it's a great book. And if you're starting from a position of neutrality, then you weigh the evidence for an issue or against an issue. You balance it, you analyze it, and you confirm or deny your hypothesis. And if you go into it with some experts, you find out they're not starting from a position of neutrality. They're starting from a position of XYZ. And that's why you always, whenever I'm against the defense, I always get the letter that the defense lawyer sent the doctor. And I know we all do that because, and I know if you've been bitten by this, you're more careful later, is you don't want to send the defense, I want you to send an opinion on this, this, and this. My letters to my doctors, I try to do is, here's a bunch of records, review them and call me. That's it. I don't want to feed them my stuff. And I don't want to have an appearance of impropriety on that too. I really want them to come in and say, like, so if I have a case with the degenerative back condition of my client, I want to be able to say, my doctor, hey, he had prior injuries. He had prior this. Or you took the X-ray. You saw the disc height was down, or whatever. That we can talk about different medical. And we had a question: is the problems they're having now from this car wreck, or is it from before, or is there a combination? Can you suss that out for us? And then you want the expert to say, yeah, we looked at that, and here's what we did. I looked at this stuff about it and after, and yes, they were injured in 99, and they treated to 02, but then they were asymptomatic for 15 years, and then 2017, da-da-da-da-da-da-da. And then I think that's, we may have to, we may have to do a little bit more work, find those articles about that, find that medical articles about that, so that those opinions and those issues can be supported.
The only thing I would add is that I think this goes to this concept, and this will certainly come out in the briefing, is your expert doesn't have to be right. In the hearing, what I found, and when I was looking at and sort of trying to think about what is the defense doing in their 5 challenges, a lot of it had to do with, we think your guy makes unallowable leaps in logic or scientific method. He goes from fact A to conclusion B, and he doesn't give you the interim steps, right? But they also said he didn't look at all of this information that we say is relevant. Honestly, that was the easiest stuff for me to deal with, because what you find in a lot of these Daubert hearings is that the challenge that is being done to your expert is about the weight to be given. Again, your judge is the court is not the finder of fact. This isn't the trial. This isn't the jury. So your response to and if you're a defense lawyer, I suppose you're trying to show that you're trying to say you didn't rely on sufficient facts. When I'm the plaintiff's guy, I'm looking at that and saying, Your Honor, that's about the weight to be given my client's or my expert's testimony. So we don't go there. That's not your job. Said in a nice, legally palatable way to a federal district judge. That's not your job. You're not trying to find out whether my guy's right or wrong. Let's wait for the trial to do that. You're just trying to find out, did my expert do enough to get over this standard? So the only, and the other thing I would think that's important to point out is that, the judge has really wide discretion. Really, really wide discretion. So
I just wrote abusive discretion standard and circled it.
So
you were thinking the same thing.
That's the only, when you get, I'll talk about one other case. I have another case that's currently on appeal at the 7th Circuit, also a product defect case in a different district court. It was in Wisconsin. And just short story about that case. In that case, we actually had exponents, the people that are on the other side of my Ovens case. And the exponent guy had a great report. But the defendant said he made a mistake. He made a mistake in the report. The judge in the District of Wisconsin, actually a Carter appointee, a Jimmy Carter appointee, said that the mistake rendered his opinion flawed under the Daubert standard, and she struck it entirely, and then she denied class cert. So we went to the 7th Circuit, and we had all these arguments, and a lot of back and forth about, does one mistake, render your entire argument? First of all, we said it wasn't a mistake, but even if it was, assuming arguendo, if it was, can you strike the whole report? So, you've got to be, and when I came out of the Seventh Circuit hearing about 3 weeks ago, my sense was, yeah, we could win, but we have a really narrow path. There's a lot of ways. If the judge doesn't like your expert, there's a lot of ways you can make it go away. And so again, I just come back to that checklist that went around. You need to be on your expert from the word go about what they need to be thinking about. Because listen, some of these engineers or doctors they're not thinking they don't understand Daubert, they don't understand the testimony. Some of them have testified a lot, some of them haven't. Some haven't testified a lot. So you need to be getting them to think, what does my report look like to the judge who's deciding whether I'm ever going to get to say this to the jury, right? So you got to get them thinking that from the start.
Thanks, Mike. I have an expert I'm producing in a month, and he wrote a report, and I said, give me this, this, and this. And he said, well, I've done this a lot before. The Highway Patrol accident reconstructions you deposed did all this stuff. Do I really want to be duplicative of this? And I said, you know what? You're right. I don't want you to be. And he's a pro, and he was great. And so you do want to do that. Let me just shoot a bunch. And do you guys have any questions right now? I'm going to run into a bunch of different other little points, and some are particular and some are a little removed. Does anybody have anything they wanted to ask or visit with us?
Do you think that the changes are substantive or procedural? Because, for example, I just took a depo like 3 weeks ago. Case is probably not going to go to trial till December.
I think that any case tried after August 28th is going to have this standard, because this is an evidence standard at trial. Does anybody have any other view of that? The things like caps and some of those other things were cases filed before or after. I haven't seen a lot of research on this, so I don't want to say with definiteness, but I'd be ready. I hear you.
It doesn't say in the statute, does it?
No. It says effective August 20. It is effective August 28th, but it supplants the. There's no more old expert statute anymore. It's not on the books. It's gone. They took away the whole statute. They say this repeals the entire old statute, and we're putting in an entire new statute. I quoted it in the materials. Let me do a couple more. Let me talk about a couple more things. Then we're going to take a break, and then Mike's going to talk to us about class actions. It's an abuse of discretion standard. You don't want to piss off the judge, and so you need to really understand that and be cognizant of that. How are we going to get in our medical bills now? Is that doctor an expert on medical bills? No, but I'll tell you, every day, spend some time with your expert, with your doctor. You got to, this. It can't be 15 minutes before the depo anymore. It's got to be an hour before, because you'd be surprised. I start talking to these doctors, and they're like, I get these objections on a foundation for the doctor to talk about bills, and then I say, and you find out the doctor has been billing for 30 years. He's got a person who reviews every year. These guys and this goes back to the pre-DEC arguments we used to have on billed versus paid and other stuff, and the foundation for bills is some of these doctors really know their stuff, or they have someone in their office who every year compares it to the price list every year for Medicaid or Medicare, and then they adjust their things appropriately. Dr. Gornett, if you ever taken him, he's on some national committees on billing. If someone tries to say his bills aren't good, he schools them, because he's written about this. He's amazing on that. So you never know. So you got to get into this. So you really got to force yourself to think, and you can get ambushed if you already took the depo. I get it. But you really got to step back and think about those foundation issues and really challenge the other side on that, and if they're going to sandbag you and try to, they didn't give you an objection on that. You said the opinion. Now they're going to come in and challenge you on that. Well, they didn't do it then. They gotta do that. I always talk about having your expert be a professor teaching, not someone talking at someone. I said you don't want to plow old ground. Do you really need an expert actually to testify about that stuff? when you cross the other side, when you use the defendants, I don't want to keep looking at you as a defense lawyer, but or one of the examples I have, Sean, is with your old firm, where I have in here about using a doctor without ever seeing someone, and always talk about. So when you cross the other side. Three more points. When you cross the other side, what are you going to get from the defense doctor that's going to help in your case? Doctor, you agree that that sometimes degenerative conditions are asymptomatic and don't bother people. Yes, I do. Doctor, you ever see that study where 60% of adult males over 40 have herniated discs in their back and they're asymptomatic? Oh, yeah. You agree that that you have to look before you cut, don't you, doctor? You agree that's a safety rule. Why do you have that rule? Well, we want to protect people. Isn't that really important? So you establish all this basic stuff with the defense expert. The other side can't come in and say it's not peer reviewed. Their own doctor says the same thing. And their defense doctors will do that all the time because, on the ultimate issue, they're leaning the other way on the degenerative, but they're going to agree on basic principles of medicine all the time. And so I sit there with the defense doctor and get all the basics. And then when you walk in at trial, you say, everybody agrees that this is a safety rule that has to protect everybody. And everybody agrees that we have to protect da-da-da-da-da-da-da, and then we're applying that safety rule here. Everybody agrees that this principle of mechanical engineering goes back 20 years to da-da-da-da-da-da-da. So you need to, maybe you can get some traction if the defense, if they have an expert there. And then what you're really disagreeing with such and such doctor is whether or not the spondylolysis is causing this problem or whether this incident impacted this disc. The other thing is when the other side's deposing your doctor, you're deposing your doctor, make sure you get in, or if you're going to call your doctor live and the other side's done, you got to ask your expert more questions now. You just can't sit and say, I'm going to make my foundation at trial, because they're going to kill you, because they're going to strike them. So you got to get up and I talked to my friend Jim Gurl the other day. Every case he has, he goes and he establishes his case with his own expert after he's done. He was bitten one time where his expert passed away before they did it, and he read the depo at trial and won the case. So you got to sit there and go over some of this stuff with your expert after they're done, and keep a little line on that. I always, and when you're crossing the other expert, go get their other stuff. Right, you can still use a deposition for any purpose in Missouri. So you can bring depos from other cases and cross them on stuff they say in other cases. In my materials here, I provided some.
Is that during the Daubert hearing, or actually during trial, or during deposition, that you would bring in materials, statements from other litigation?
Great question. Depends. You want to catch them. So sometimes you may not want to do it to trial. But if you're at a Daubert hearing, as Mike said, there's no rules of evidence. You can bring in anything, okay? So if you need to say, but doctor, you said this, this, and this, and other things, it also opens up. I mean, if you want to start wars with the other side, you sit there and go sit there and subpoena Marvin Mishkin and say, tell me every case you were on the defense side. Now tell me every case you're on the plaintiff side and see what happens. I'd always go after an ex, but there's a lot of doctors that are like that. Or, what about in comp? I mean, anyway. The doctors tend to be on one side or the other. That's why when you go seek an expert, my perfect expert is someone who does both sides, and they call it like they see it, because that's what a real expert is. Always go after the other side's money. We're not when we originally did this, set this up, we were going to talk experts, and then Daubert came down, so we really focused it. So I got a lot of other stuff I got question examples and some other things. Always talk about the other side's money. Jurors hate it when a guy's making millions of dollars a year to come in and say the same thing in every case, and there's specific ways to do it. I have examples there. I say, how many IMEs a year, how many depots a week, da-da-da-da. You do the math real quick, you do it, and you find out they've been doing it for 20 years. They're making millions of dollars doing this stuff. Steve.
And how do you get your hands on, more basic question,
Trial Smith.
How do you get your hands on prior litigation depots?
Trial Smith. Trial Smith. So there's Trial Smith they have thousands and thousands of depots. You can buy a subscription. If you don't want to pay that every year, you're going to go with depot. You can just do a one-time search. You can see what they have. Then you can buy the depots or not buy the depots. You can do one of the things. We got to work together. So you put on something on the MATA listserv or the Solo a small firm listserv. I'm going to go depose this guy. Does anybody have the book on him? And someone usually does because someone's done that work. And just sharing and helping each other.
And from the federal side, I mean, it goes to...
Oh, and can I say one thing?
Sure.
Ask them what their 4 years or 10 years of testimony is, and then they got to tell you. I gave depots in this, in this case. Give them a thing. I mean, especially with Daubert, it's very relevant. Tell me every case in the deposition who the other lawyer was that you testified about X, Y, Z. And then they tell you and you say, give me the stuff.
So from the federal side, and that's most of my practice, Federal Rule 26 actually governs this, and it requires that you disclose the 10 years of testimony or 4 years of testimony, 10 years of publications.
Upon request? Or
no, it's required. And that's why
in the expert disclosure section of 26.
Yes, and that's the key part, I think, for the Daubert hearing, and to connect these two. You have the disclosures that are required. This is federal court, but it's probably going to get incorporated into the state rules. At the Daubert hearing, you're defending the report. You're defending what they did to write what they said. Okay? And, yes, that's why when I was in the middle of the hearing and the defense guy who was, trying to do, I felt like he was doing a lot of Perry Mason-esque sort of flourishes, like, sir, and he held up like these big charts of all the ovens, like that, all the models all through the years, and there's like 2 million of them, right? And he goes, sir, can you show me exactly where the plaintiff's ovens are that you tested? Because my guy went to the homes of the two plaintiffs with their guy, and they ran the ovens. When they walked in, they ran the ovens, they tested them, they both failed. They retrofitted them according to Whirlpool's all the technical service bulletins, ran them again, they failed, right? So he stands up and he has this board and he says, can you identify what and my guy says, well, I can't, but that's not why I'm here. I'm not trying to testify. And that's the point to the judge. That's weight. Okay? A jury, if we get over the hill, there's ways she could say, hey, he didn't do enough testing. But honestly, if you get down to the nitty-gritty of what this means, whether or not they're right or whether or not my guy's right is not the point of the Daubert hearing. The point is whether my guy relied on enough information, used reliable principles and methodologies, is qualified, and his testimony will help the trier of fact. Right? Those are the basic fundamental concepts. So, I guess what I would say is at the moment you're in at least in federal court, maybe eventually in state court, and your expert has written a report, you're defending the report. You're defending that what was in the report and what they asked him about the report at the deposition, because some of that got played. They played some of that. Well, you said X. Okay. Again, in general, as a general matter, you as the plaintiff's part, you're arguing, hey, listen, they're talking about weight, they're talking about the jury, they're talking about the finder of fact. My expert did the right things based on sufficient information, and it's on reliable principles, and the jury ought to hear it. They're deathly afraid that they'll ever hear this opinion. So
we got a lot of stuff appended to the some orders, some cases, and some other stuff appended to the expert material. And that's it. We're done. No, go ahead, Mike.
Okay, I put in the standing order of Judge St. Eve, and I'm just going to say this. I know this is really fundamental, but check the rules. Check if your judge has a standing order. And to your question about, where do you go find the material about the experts? Find the material about your judge. Okay, I know that you just introduced in Missouri State Court, and maybe you won't find a lot of Missouri cases on it. But in federal court, you know, Judge Amy St. Eve had already written multiple opinions on Daubert. You know, you need to know those backwards and forwards to know what she cares about when she's looking at a Daubert question, right? So you have to do that research. You got to look at the rules. It's basic stuff.
Thank you.